Holman HR presents HR Fun and Stuff, infotainment that'll have you laughing, listening, and learning. With no further ado, here's your host, Michael Goldfarb. Welcome to another Holman HR video alert. I'm Michael Goldfarb, your host, president of Holman HR. In this video alert, I'm going to set forth a scenario. We're going to discuss and spot all the issues in the fact pattern and find solutions. This is a great review for those of you with substantial HR experience, and for the newly indoctrinated, this is a good way to become acquainted with some of the more complex issues that you're going to encounter as an HR professional. So let's get right into this and start with our story. This is a story about Barbie and Ken. They were two very happily employed individuals working for the company of Tiny Interior Design and Apparel. Barbie was the head of the interior design department, and Ken was one of the firm's top fashion designers. Both had been employed with the company for 5 years. They were really good at their jobs and received good to excellent reviews on a consistent basis. As a matter of fact, Ken's work was so outstanding that the company recently launched a line of tiny apparel simply called By Ken. Barbie was also making a splash for herself within the company and had risen up the ranks to become the vice president of the interior design division. She was in charge of it all. Barbie was so good at what she was doing that Tiny's interior design division quickly surpassed apparel to represent 65% of gross revenues. But there was a price to pay for this success, and the company was working her 15 hours a day, sometimes 6 days a week. As a result, Barbie started developing migraines, and it got so bad that she had to start sitting in a dark room with cold compresses several times a day just to catch her breath. Though this slowed her down, nobody in the company said anything. Finally, the pain being too much, she went to her doctor, who diagnosed Barbie with severe anxiety disorder. As a result, the doctor prescribed a regimen of working no more than 3 days a week, 8 hours a day, for about a month, and then they would reevaluate. Ken, too, was doing amazingly well, except for the fact that in his division, it had a reputation for a fiercely competitive sector of the company. Not only that, but the VP played favorites, and Ken was not one of those. Like Barbie, Ken started to feel anxious about his job, and he reported this to his supervisors. Nothing was done, Ken was getting worse, so he went to see a social worker and was diagnosed with depression and anxiety disorder. The social worker recommended that he take a minimum of 3 months off, and that when he returns, he's not to have excessive contact with that supervisor. But Ken was also told, and it was included in the medical certification, that if he didn't heed these recommendations, there's a good chance that he could suffer a nervous breakdown. Well, the next thing you know, as head of HR, you're sitting in your office staring at the entire board of directors, and needless to say, they aren't smiling. They're looking at you, they throw down these medical certifications they've received from Barbie and Ken, and all they have to say is, "What do we do now?" So what are the issues that are presented? Well, first we have to determine if in fact Ken and Barbie are disabled employees. Then we're going to have to go through the issues of paperwork to establish legal obligations. Next, we have to look at the interactive discussion, which will talk to us about reasonable accommodations, qualified disabled status. Lastly, we have to track status. We talk about the return of the employee or extensions on leave and COBRA and possibly termination. So those are the universe of issues presented in this fact pattern. Now let's take each one on their own and analyze and discuss how to work through them. So the first question we have to answer is, did the company have adequate notice that its employees in Ken and Barbie were in fact potentially disabled or disabled? Well, the ADA and most state equivalents pretty much break notice into two categories: actual or constructive. Actual notice is what you would think. It's when the company has actual notice because somebody has presented something in writing, like a medical certification or so forth. Constructive notice is much trickier. Constructive notice, sometimes referred to as implied notice, is when by circumstance or the events that transpire, the company knew or should have known that the employee in question suffered from a disability that was negatively impacting their position. In viewing constructive notice, it's not always imperative that the employee actually state that I have a disability. As a matter of fact, under the ADA, the law specifically states that if the company takes steps or does something to accommodate an employee, albeit without medical documentation to substantiate a disability, they are now treating the individual as disabled, and therefore that employee receives the protections of the law. In this case, Barbie presented medical certifications to her employer stating the specific need for accommodation. So unequivocally now, the company there is on actual notice that they have a situation with a potential disability affecting Barbie. As for Ken, well, Ken did go to a professional in that he went to a social worker who diagnosed him with a problem, but there was no paperwork involved. And what Ken did is he went to his supervisor and verbally told the supervisor of the recommendations of the social worker and his situation. Well, does that amount to notice? Likely, yes. That would be notice. That would actually be actual notice. It was given to a supervisor. The supervisor is then tasked with taking that information to human resources and acting upon it. The fact that the supervisor might not do that doesn't negate the reality that Ken has now probably been considered legally to have actually provided notice to the company. The next step in the process is for HR to explain to the irate board of directors that there are legal obligations and paperwork associated therewith. So, what paperwork are we talking about? Well, first of all, the employer should have a handbook that sets forth the employee's rights and responsibilities when considering a disability leave. Depending on the size of the company, they may have to include FMLA coverage in there if they have 50 or more employees within a 75-mile radius. Then the company wants to have a letter with explanation of rights and responsibilities. This will set forth basically a reiteration of what's in the handbook. When the employee in question is sent, in this case Ken and Barbie, that letter attached to it should be two documents. One should be a medical certification and the other a job description. Why? Well, the medical certification is what the employee is going to take to the doctor to establish the need for the leave and give the company guidance on the extent of the length of the leave and a basic diagnosis. Very important that if the company falls under FMLA guidelines and therefore any other state which has an equivalent, for example, California has the CFRA, which is the FMLA equivalent at the state level. That medical certification has to be very limited in scope in terms of the information elicited from the doctor. Under, for example, the CFRA, an employer is not permitted to know the details of the diagnosis, rather simply that the employee cannot perform the essential functions of the job due to a serious health condition. So going back to the documentation, we have the handbook with the initial policy. We have a letter of explanation of rights and responsibilities, and we attach to that a medical certification, a job description, and of course we give the employee a certain amount of time to get that back. And then we calendar that time frame so that we're on top of it and we don't let this slip through the cracks. Far too often, employers don't properly calendar to get that information back, and the next thing you know, a year's gone by, employees still on the healthcare roll, and they're just simply on some unknown type of leave. That's not a good situation to be in. So we've gotten the paperwork out, and the employees have gotten it back. Ken and Barbie have returned the paperwork, and we pretty much know what it says. So we're moving on to the next step. Probably the single most important aspect of an ADA disability analysis, that is the interactive discussion. The interactive aspect of the ADA is actually codified. It is part of the statute. And in and of itself, in other words, the failure to perform an interactive discussion with an employee requesting some type of accommodation is itself a basis for a lawsuit. So that's why it's so vital that we want to remember that failing to actually engage in that process constitutes a legal claim. So of course we're not going to make that mistake, and we've now been presented, Barbie's presented us, with her medical certification from the doctor based on her job description, and it says that she cannot work more than 3 days a week, at least for a month, and on the days she does work, no more than 8 hours. Okay. Now, I would say on the surface that sounds like a pretty reasonable request, because that's the term that we're looking to find. Is or is not the request reasonable? Here's the rule, here's the law. If the request can be reasonably implemented, it means that there is a reasonable accommodation. If there is a reasonable accommodation for the particular employee requesting one in respect to a disability, it then means that that individual is now a qualified disabled employee. And that is a significant change in status from being simply disabled to a qualified disabled, because once somebody is a qualified disabled employee, they now reap the full protections of the ADA and likely any state equivalent with respect to their job status. So again, when an employer can accommodate a request for some type of accommodation, it means the accommodation is reasonable. That translates into meaning that the individual is a qualified disabled employee and now protected. Well, let's take the case of Barbie. Now, Barbie happens to be the head of the entire division for Tiny's interior design. Well, that's pretty important, and I don't know for certain, and we're not gonna reach a conclusion to that yet, but it could make Barbie indispensable, or more commonly referred to as a key person. There is a defense to providing certain accommodations, especially ones involving limited time on the job or a leave of absence, and that would be if someone constitutes a key employee, indispensable to the running of the business. If that is the case, then by virtue of their status, that request would be what? Everybody knows the word, unreasonable. As such, it's undue hardship, and that's a defense to providing the accommodation. Now, in this instance, we're talking 3 days on, 2 days off, 8 hours a day. If I was the employer, we'd probably want to give it a trial run. And if it made the business near to impossible to continue with any degree of profitability and certainty, then there's a good chance that we might be able to say to Barbie, I'm sorry, that's unreasonable, we can't do that. And if Barbie would be unable to work, then there is a possibility that she could be terminated despite the fact that she's disabled. Well, now let's turn our attention to Ken. Ken is in slightly a different situation. He verbally told his supervisor that, he went to a social worker and he's having these problems and it's affecting his job. Nothing was done. So what could happen as a result of that? Because what we're seeing here is we're really moving into the later stages of the ADA analysis, but we have no paperwork. So could that embroil the employer in a problematic situation? It certainly can. It can do it in several ways. But let's take the option that Ken is not performing well, and he's made it known he's having some issues that a social worker said is due to anxiety and depression. The employer would be well advised to have a sit down with Ken, but solely on the issue of performance. In other words, we're having a performance review because it's not up to snuff. Now, if during the course and scope of that discussion, Ken reiterates that he believes it's due to a diagnosed problem involving depression and anxiety, well, now you have a situation where basically the company's on notice, paperwork or no paperwork. And if the company took a negative position towards him in terms of a tangible negative effect on his job, termination, whatever, demotion, whatever the case may be, Ken would have a pretty good argument that that's disability discrimination. So in the situation where if we didn't send Ken to get documentation and we had this performance review and he brings this up, the company is still obligated to jump to the next stage, which is the interactive discussion. And let's assume for purposes of this discussion that Ken brings back the paperwork as requested, fully completed, and it does state that he has severe anxiety and depression, and he's instructed to take 3 months off work, and even upon his return not to have excessive interaction with that supervisor. Okay, so what do? Well, Ken is I'm not going to say just, but Ken isn't in charge of his division. Ken is a very well-known and respected fashion consultant or designer. As a matter of fact, the company has a line of clothing with his name on it. So if we're thinking about that key person defense, does it apply to Ken? Well, chances are no. Why? There's a good bet that this company could find other designers to cover for Ken while he's gone for those 3 months, that in that process they can make up for his absence. Now, is it possible that Ken's contribution is so unique and he's the only one that can do his line of clothes? Okay, that puts us into a different realm. But chances are that isn't the case, and others can pick up the slack. And if that's the case, then that request for 3 months off work certainly is reasonable. And to deny it would be an unreasonable interference, and to punish Ken for that request would be a classic discrimination case. Okay, we've gone through the interactive process. Barbie's been fine. She got the time she needed outside of work. She's back on the job, doing swimmingly. Good for Barbie. On the other hand, Ken's situation's a bit different. He was out for 3 months. He was supposed to be back, and he's not there. Okay, so let's track what we did while Ken was gone. Well, the first thing is we calendared when he was supposed to be back. And as part of our calendaring process, we also calendared a date for when we were going to send Ken a reminder letter that reiterated his rights and the company's responsibilities, which included his return date, and the fact that if he needed more time off, he needs to notify us in writing. We enclosed an additional medical certification if he needs an extension of time. We also included a return to duty clearance form that Ken needs to get signed off on by a medical practitioner saying he's okay to return. Now, Ken doesn't return. We want to send Ken another notice saying, hey, Ken, maybe you just forgot, maybe something's not right, I don't know, but you need to be back. And if you're not back at this particular date, well, then we're going to interpret that as an abandonment of your job or a voluntary termination. It's very good to set it up that way because it is a voluntary termination, and if Ken decided he needed to move on to greener pastures, well, that's fine, but we want to make sure that if unemployment became an issue, everybody's clear that this was a voluntary termination. The other thing is we want to be able to put an end to the employer-employee relationship with Ken, because that means that we know where we are as far as benefits are concerned, like health care. Even if we were covered, if Ken was covered under his leave of absence, maybe it was an FMLA leave, so for 3 months we were having a scenario where Ken was still on health care through the group plan. Well, once Ken terminates and is no longer part of the company, that's a COBRA event. That's a COBRA triggering event. We want to get him those notifications. Matter of fact, even if Ken goes out on an extended leave of absence, he does get a medical certification. He does need the time. It is reasonable and so forth. But we're no longer under FMLA or any state equivalent. Well, Ken is no longer entitled necessarily to group benefits unless there's an internal policy that says otherwise, and so that would be a COBRA triggering event. And lastly, as we've been saying, if Ken just disappears and falls off the face of the earth, then it's a termination, and in this case we've set it up so that it's a voluntary termination. Okay, that's the sum total of issues that you need to think about when you're dealing with a potentially disabled individual. Stay tuned, because we're going to have other video alerts where we'll walk you through some complex HR issues. I'm Michael Goldfarb for Holman HR. Thank you for listening.